when XRP Law Suit throws the crypto industry off guard. Striking at the heart of Ripple's defense, the US Securities and Exchange Commission is citing its history of more than 70 enforcement actions against other crypto companies in asking a court to dismiss Ripple's argument that it lacked due process and fair notice, that XRP transactions violated the law according to a new legal filing. Could this be the dent in the crypto sector? A win by the SEC could rejuvenate its zeal to follow up other cryptocurrencies that could be violating the law. Do you want to know more about the proceedings? You are in the right platform. In today's edition on the much-awaited ruling of the Ripple vs SEC case that could see the entire crypto industry shaken. Hey guys, welcome back to our channel, The Crypto King. Here you will get the latest cryptocurrency news, all investing information in crypto, and how to earn money from crypto. If you are new here, please like and subscribe to get everything you need to know about cryptocurrencies. Don't forget to click the bell icons so you get notified every time we upload a new video. So, let's get started. Ripple's attorney asserted in a court filing earlier this month that there was a legal precedent for Ripple's fair notice defense, citing the Upton vs SEC case where a federal appeals court held that SEC could not take enforcement action when the defendant did not receive reasonable notice that its conduct was unlawful. But the SEC is now arguing that Ripple's fair notice defense rests exclusively on a single decision, Upton vs SEC, an outlier case arising under very different circumstances. Ripple hangs its hat entirely on Upton, even though Upton has never been applied to negate violations in an SEC district court action, wrote SEC Attorney Benjamin Nauer. Nor has any court allowed the Upton defense to defeat SEC charges of statutory violations such as Section 5, as opposed to the SEC novel interpretation of its own rules, as was the case in Upton. The lawsuit between the SEC and Ripple is most likely ending in a pre-trial settlement. 96% of all SEC cases are settled before trial, of which 60% before litigation and 90% in discovery. At the SEC vs Ripple is expected to provide significant precedent for the crypto ecosystem. The whole industry is watching every new episode of the legal battle. We have recently covered Attorney Jeremy Hogan's take on the far-reaching consequences of a Ripple win on the fair notice defense. Today, we are reporting Mr. Hogan's views of what a settlement would look like after reviewing the Kik and Telegram cases and from settling hundreds of cases himself. First, he conjectured that the SEC will want the language enjoining Ripple from any future illegal sales and civil penalty. Disgorgement should be tricky. XRP has changed hands of millions of times. In other words, there's just no way to fairly disgorge profits to investors because there's no way to fairly knowing who to disgorge to. Then, Mr. Hogan pointed to Ripple's likely priorities. To maintain its business, a penalty or disgorgement must not bankrupt the firm, and clarity moving forward. Lawsuit is about past and current sales of XRP. For Ripple, the first thing it will be looking out for is the ability to resume business. For some crypto companies, the SEC charges drove them out of business, like Paragon Coin. If a penalty imposed, or if there will be disgorgement of profits from sales, it will have to be at the level that does not bankrupt the company. Whatever number we see in the settlement, it will be a number that Ripple can afford. The second thing that Ripple will be out for is clarity moving forward. Ripple and the secondary market need to know that the SEC debacle is behind it. According to Jeremy, the SEC would never agree to drop all future charges against the secondary market for XRP securities violation. However, the regulator can make it clear that sales from the filing of the lawsuit forward are not sales of securities. That's about as much clarity as the market will get. A settlement agreement between the SEC and Ripple is likely to include Ripple paying a penalty specifically limited to dates pre-lawsuit, not include disgorgement of profits to purchasers because of the impossibility of figuring out how to disburse the funds, contain a term that includes limitations on the sales of XRP released from escrow, satisfy Ripple's concern, namely maintaining its business and ODL, give the exchanges the confidence to relist XRP, possibly limit sales to private sales to companies and clients, which would bottleneck the flow of XRP into the market for years. Put XRP in clear as far as security violations, XRP would be the first crypto company to be 100% in the clear. Jeremy Hagen went into detail on many of the above-mentioned points, which can be seen in his published YouTube video. In the meantime, the SEC has asked the court to extend the deadlines for both fact and expert discovery by 60 days. As admitted by the financial watchdog, defendants do not consent to the SEC's request because they contend that the SEC had sufficient time to investigate this matter before filing a lawsuit and because Ripple wants to move for summary judgments as soon as possible. In addition to this SEC request, both parties have filed a joint motion to extend the time until June 9, 2021 to meet and confer regarding document redactions and sealing of certain exhibits, hoping to avoid burdening the court with unnecessary disputes. In its turn, Ripple filed a motion to compel the SEC to turn over internal documents regarding cryptocurrencies, Bitcoin, Ethereum, and XRP. This motion follows the SEC refusal to produce the documents despite the judge's insistence. It should be noted that the judge can order monetary sanctions or even dismiss the lawsuit for discovery violations. A few days ago, the court denied SEC's motion to compel Ripple to produce memos discussing XRP sales with the firm's lawyer, a motion that Ripple Labs argued went against the rule of attorney-client privilege. This was an important win for Ripple. Cryptocurrency experts are closely watching a legal battle between Ripple Labs Incorporation and the Securities and Exchange Commission, anticipating the case could establish precedent and clarify the regulatory landscape for digital coin offerings. The SEC last year sued the company, CEO Brett Garlinghouse, and Executive Chairman Chris Larson in the U.S. District Court for the Southern District of New York, alleging they should have registered XRP under securities law. Ripple and its executives have asked the court to dismiss the case. Ripple scored win in preliminary rulings in the federal court, including gaining access to internal SEC documents and shielding its executives' personal bank records from discovery. Holders of Ripple XRP cryptocurrency at issue in the litigation were also granted permission in April to intervene in the case. Those wins don't necessarily foreshadow a victory for Ripple, but the case is on track to establish legal precedent for the SEC authority over digital coin offerings, according to Drew Hinks, a lawyer at Carlton Field, PA, in Miami, who works on cryptocurrency matters. This is a significant case, Hinks said in an interview with QC Roll Call. Ripple has tremendous financial resources, has assembled an incredible team of well-respected lawyers, and has one of the most high-profile projects in the industry. Thank you for being our guest. To be the first one to get the latest hot trending news on the cryptocurrencies, kindly subscribe to our channel. We request a special favor from you: kindly like, comment, and share with your friends.